guys, it's Kathy. I hope you're doing well. We made it to Tuesday, alive and well, still kicking. My internet went totally down at 3:58. So if you're in another time zone, I go live at 4:30 a.m. every morning, and my internet went down at 3:58. Don't worry, seems to be holding. We're gonna do a Sov Cit today. Not full blown meltdown crazy, but enough. Just crazy enough to start the day off. And then we're probably gonna stay in Colorado mostly today, I think. Who knows, we might venture into Indiana, but probably not. Yeah, you'd think I would know, but I don't. No idea what we're doing.
This is 25M2378, People versus Alan Herrera.
Anders Erickson for the people.
I'm Mr. Herrera, right at the podium.
All right, so he was supposed to be here earlier this morning. Can you tell me what happened?
Thought his court date with that.
Position with regards to the warrant.
No objection to quashing it, Your Honor.
So given that he did appear today, I will quash the warrant, reinstate personal recognizance bond. We need to issue a mandatory protection order because I don't think one was ever issued in this matter. Let's see. So it looks like, Mr. Erickson, you want the listed victim protection order in boxes 1, 2, and 3. Is that correct?
Yes, Judge.
All right. So, Mr. Herrera, I am required to issue a mandatory protection order in this matter. It quite frankly should have been done a long time ago, but it looks like it was an oversight on behalf of the court. So I'm going to issue it today. It will list Margaret Kirshner as the listed victim or protected party. This protection order will state that you cannot harass, molest, intimidate, retaliate against, or tamper with any witness or victim of the acts that you are charged with committing. You must also vacate the home or stay away from the home of any of the listed victims or witnesses. You must also avoid any stay away from or avoid any other location where they are likely to be found. And you must refrain from contacting or directly or indirectly communicating with any of the listed victims or witnesses. Do you understand those conditions?
Your Honor, it's I just want to say that I'm the beneficiary of my account, and but we can proceed with this matter as director and beneficiary and executor of my own trust account. I have 21 days to show me a proof of claim of writing. They have jurisdiction to bother me at all. Until then, I do not consent to proceed. My next question is this a common law court? Because I represent myself under common law, or is this an admiralty court?
It's not an admiralty court.
By the way, I just want to say that I'm followed by a group of people. They gang stalked me and followed me with so many different strategies. I believe it's a police cult. And they're also, I'm going through some systemic racism that I've been going through for years.
I believe that.
And the day when the alleged allegations were created, I didn't see anybody. I was on the bike trail. Nobody was around me. So my question is, do you charge people when they are close to you, or do you charge them when they are far away? And people taking their own time to use accusations? Because this is what this ticket, I'm being held here for something where I didn't see anybody. I got off the bike trail, but there was nobody around me, so there was people watching me. And to me, that's what I'm explaining about this.
So certainly, Mr. Herrera, I'm to talk with Ms. Nasri, and she can certainly answer any of those questions for you.
No,
All I'm
she
asking
can't.
at this point is whether or not you understand the conditions of that protection order. Do you understand those
I
conditions?
need an intern.
Yeah, I comprehend. to stay away from the person, which I don't even know who she is. And yeah, I'll stay away and mind my business, you know, like I got no business.
Hi, Randy.
I don't even know who the person is.
Okay, so knowing that you don't know who she is, it's not going to be an issue for you. It doesn't sound like so. That's a good thing. So we'll give you a copy of this order today. You're welcome to take a copy with you if you would like. You'll need to sign it before you go. And then you'll have time to talk with Miss Nazary further about this case, and she can certainly answer those questions that you have, okay?
And I just want to say I don't consent to the social experiment I'm going through. And that's just my situation. Everybody's case is different, but this is what I'm going through. And I believe President Donald Trump and other people been going through certain type of like harassment through different ways, you know what I mean? But all I gotta say is if it's not intentional and I could face my accuser, then you know I'll try to make it right. But like yeah, like I'm here to show up for this. And for the record, I didn't know court was at 9:30, and I thought it was at 1. And I just rode like just trying to get here, and I'm glad I made it at least. But thank you for your time. Thank you for your consideration, everybody.
You're welcome. So let me get
consent to all
you a new
experiments.
court date. Miss Nazary, how far out do you want to set it?
Just say, let's experiment. I'm in. Let's
I'd
do it.
also like to request a bridges liaison.
Okay. I can do June 15th or June 16th.
Let's do
If I got to work, I'll take time off. Like you know what I mean.
June 16th, that one.
Okay. So, Mr. Herrera, I'll set you June 16th at 1:30. If you need a reminder slip, we can get that for you before you leave today. Otherwise, just make sure you stay in touch with Miss Nazary. I will grant the request for a bridges liaison as well, and she can talk to you about what that means, okay?
All right. Thank you, y'all, and yeah, have a blessed day. Thank you, y'all. Shalom.
Hold on, Mr. Herrera. Miss Nazary's going to try, we're either going to do an order or she's going to try to get the eval from the other case. All right. All right, Mr. Herrera, take care. Have a good day, okay? They'll call you up in just a second, okay? Come on up, Mr. Herrera. Great, I think that takes care of our docket. Do you all have anything else?
So he tried a little bit.
Okay.
It didn't work. Let's go to this guy, girl, I don't know, person.
Picked up new cases while on supervision and probation was revoked. We have multiple failures to appear in this case, including failing to appear for motions and jury trial. I think at this point it's pretty clear she will not change her ways. The PSI notes she indicated a struggle to pay living expenses. The public defender app shortly after that noted she didn't qualify and had employment, and she managed to pay a significant amount of cash only bonds and then retain an attorney after the fact. So I think to this day she's still not being honest about her finances, and she's being sentenced on these cases. But I think the PSI even touched on it. That 2010 CR 2325 case sort of started off this pattern of lying and stealing money. And I think it's relevant to this case because time and time again, she's tried to use her health as an excuse for her failure to appear. And time again, we've never gotten documentation of that. And she's just failed to appear. And we have these incredibly lengthy delays. That 2010 CR case is noted in the PSI where she lied about having a cancer diagnosis and had Lakewood Police fundraise for her significant amounts of money. And it's referenced because I believe she still owes restitution on that. Years and years of thefts. She repeatedly gets sent to the Department of Corrections and doesn't change her ways. I don't think it makes sense to put her back out in the community on supervised probation when she constantly makes the choice to lie and steal from multiple businesses and people.
If I could just move into someone's house, live in their basement, and play video games, yes, I would, 100%.
So we are asking for the court to impose an 18-month Department of Corrections sentence on the motor vehicle theft. We do not object to the 142 days of pre-sentence confinement credit in 23 CR 3217, nor do we object to the court imposing a 364-day concurrent jail sentence on the fraud by check. That was an added count to encompass the conduct of the apartment check. That was a check by fraud case. That case is being dismissed, but the misdemeanor pleas in this case. And then we're not objecting to a concurrent 120-day jail sentence on the M2 forgery in the other case. Counsel did math at 77 days of pre-sentence confinement credit. As I've been reading the mitigation letters and doing the math, I don't object to that amount either.
Okay, thank you.
And there has been no restitution requested in either case, and we're not asking for that to be kept open.
All right, thank you. On behalf of Ms. Kroll?
Yes, and Judge, first with regards to 25 CR 1800, I would ask that the court go along with the proposed agreement and that the court impose 77 days of jail and give credit for 77 days to close that matter out. The 24 CR case would be closed with the prosecution, the subsequent motion, leaving us with the 23 CR case. And just to, I guess, briefly provide my...
You know what else is a thing in Australia I just found out about? You're driving down the road, right? And there's a speed limit that you're ignoring. They have these speed bumps, but they're not speed bumps where you drive over a speed bump. No. There's these things in the road that if you're driving too fast, it like drops. I haven't seen a car hit one yet that it dropped, because apparently people in Australia know better than to drive too fast on roads with these. But I would love to see one. I haven't really searched. I haven't put any effort into it. But I've seen these. I don't know what they're called. I'm just going to call them speed bumps because I don't know what else to call them. You drive down the road and then your car falls down. Oh, man.
opinion on, I guess, the facts that were discussed in these cases. The allegations were that she attempted to secure 2 cars in an apartment. It's not like she's trying to get a watch or material things in that nature. These are things that we commonly need to survive in today's day and age. So I guess I disagree with that characterization, and I also know the prosecution referred to it as a nice truck and an Audi. They're used cars. The Audi, I don't know the exact number off the top of my head, but it was either $13,000 or $16,000 for the Audi. So I just want to make sure the court has the correct picture in your mind that this is not a brand new car that she's going to buy from the dealership. These are used car places. It doesn't make it any better or justify her conduct, but it does put into consideration she really is just trying to make it by. She's trying to get an apartment. She's trying to get cars. These aren't material things that she's going to a pawn shop and trying to steal or something along those lines, which does explain somewhat what she's going through. As the court can see, she had a period of time recently where she didn't have that stability in her life. 23, 24, 25, she picks up those 4 cases. However, since November, she was sentenced to probation in that Denver case for a period of 2 years. And then she remained in custody in these cases until January 30th. So since January 30th, she has been out on bond in these matters as well as probation in Denver. And from what my understanding as far as Denver is situated is she owes $7,000 in restitution there. She is current on making those monthly payments and is, compliant with probation there so far, recognizing she's been out for, 3 or 4 months there. But that does show the court at least some glimpse in the most recent history that she can comply with court orders, both in this case, as far as bond goes, and probation. I don't know if the court is aware of Judge Egelhoff in Denver, but he's not afraid to voice his opinion if he thinks a plea agreement or a sentence is not appropriate. I wasn't there for that sentencing, but the fact that he thought probation was appropriate given this circumstance, which I'll explain more in a moment, I do think is persuasive. Obviously, it's Your Honor can sentence to DOC or probation here, but ultimately my request is that Your Honor sentence her to probation to run concurrent to the Denver case and suspend DOC so that she has some responsibility if she cannot be 100% compliant here on probation. She's shown that she can be over the past several months, and I think she can continue for several reasons. One of those reasons, or some of those reasons, are outlined in those letters that I provided the court. She has a stable employment. She has a stable job. And it's really important to me when I look at a situation like this, and is someone going to be successful on probation? And largely that can depend on how open and transparent are they with their struggles. And so here, as outlined in the PSI, Ms. Kral's mental health struggles really stem from the feeling of inadequacy and not having the ability to obtain things like a car, and it results her into making these poor decisions, which should be best addressed through treatment to some degree, and not just putting her back in prison and saying, we'll see you in 1.5 years or a couple of months, whatever the math ends up being. But that doesn't really do anything for her. It just says, we're going to prolong this. We're going to make sure that you lose all of your stability when you come out. That's not the intention of the court sending someone to DOC, but that's the reality of it, is that she is going to lose that job that the court saw the letter from her employer, who's aware of
What about the crime, sir?
what's going on, and was still willing to write that letter in support of her, saying, we're going to keep her employed. She's a good employee. And so that having that steady income, that stability, is going to be crucial for her success in the future. She also has, a home that she's renting with a friend that she's known for 15 years, who's also aware of the situation, and they're supportive of each other. So she has a stable place to live, stable employment. She also has parental support, as the court also saw from her parents that wrote her a letter. It was her father, but they both, signed it, if you will. Recently they've been very involved in Ms. Kral's life. Ultimately, they were the ones who paid me. I know that was used against Ms. Kral. I took a significant discount because it was the right thing to do for Ms. Kral, and ultimately her family paid me. I'm not sure how appropriate that is, but since that was brought up, I do think I wanted to address that.
I want to steal a scissor lift, but that's not a car, right? My boss really needs one. We really need one. Our ceilings are so high. We have all these hand-painted lanterns from Vietnam up there, and we have to keep changing the light bulbs. And he has this rickety ladder that he shakily walks up. He needs a scissors lift. And people just leave those outside, they don't take them inside with them.
That she was not able to pay for my services. And when she was released from jail, she did try to qualify for the public defender's office, and unfortunately did not qualify, and was really stuck between a rock and a hard place when someone makes too much to qualify for the public defenders but doesn't have funds for public defenders. She certainly could have went out, tried to steal
What about
something.
her victims?
She did the right thing. She asked for help from her parents, who contacted me, and we're all here supporting her now. And so I think that consistent support from her family, who's aware of what's going on top of the employment, on top of the friend with her living situation, really we're setting her up for the best chance possible for her to turn her entire life around.
So she reached out for help instead of stealing, and instead of just working and earning the money to pay for the things that you need in life?
Additionally, as far as the medical concerns go, I do have think it was like 700 pages, which I didn't file with the court of medical records. A lot of that comes from the jail here when she did her last stint from November to January. In December, she had a seizure in the jail. That's from a 2020, or what she believes is from a 2021 accident where she had TBI. And if she's not on the proper medication, she starts having these seizures, which are getting worse and worse. So I don't know all the medical, I guess, history that the prosecution was talking about, but I do have, and I can file with the court, where she did have a seizure in this jail, as documented by the records that the jail provided the public defender who provided me. Finally, really the best way for her to attempt to right her wrong is to pay back the restitution. There are no restitution in
Hell no, I'm not hopping in the scissor lift. I'm just going to give it to him. I don't do that. I wait tables. That's my function.
these cases, or there is no restitution in these cases. However, she does have that $7,000, $6,000 and some change in Denver that she's working on paying back. She's working on paying back the restitution from 2010. To be able to do that, she needs to be able to keep working. And so she hasn't been in a place like she is now in a long time, where she has all of these factors supporting her, aside from the criminal history, which she can't change, right? At some point, she has to have the ability, or she should have the ability to say, okay, enough is enough. Let me do what I need to do to get past this. And when I read that PSI and I see her saying, you know, I was attending therapy, I believe it's February or January. The beginning of this year, she started attending therapy because she recognized something's wrong. Something is I need help. I need guidance. How do I fight this urge? And so she sought out the therapist, or the nurse practitioner, which also wrote a letter, who is providing her medication and monthly counseling. And she actually kept in touch with a therapist that she worked with from the prison, who went into private practice. She's in touch with him on a monthly basis so that she has that bi-weekly contact. And she's developed a relationship with that ex-DOC therapist so that she can reach out anytime she just needs help. And he's very supportive and understands, you know, hey, sometimes I just need to be there for
I'm ready to hire her as my life coach now. You did such a great job, sir.
her. And so she really has everything going for her right now. And I think ultimately a probationary sentence is appropriate here when considering the factors the court is supposed to consider, which I'll just briefly touch on. So punishment, and this is from 18.1,
Briefly.
1025, purposes of sentencing. One is punishment. She's served 142 days. I think that's a significant punitive sanction here to impose on her the seriousness of these actions, that this is not acceptable, while still allowing her the opportunity of probation. Consistency, this is a class 6 felony. Judge Egelhoff in Denver sentenced her to probation as well. So it would be consistent. Deterrence, the court can suspend the max 18 months of DOC on her successful completion of probation, to make sure that she has that motivation to not reoffend. And rehabilitation, probation here is appropriate, as I've outlined. And then finally, public safety. I think, ultimately, in my opinion, if the court censored
Public safety. Let's talk about that one way more.
DOC, it's just setting her up for failure when she gets released. And that is going to put the public in a more dangerous situation than if the court allows her to remain on supervision now and keep those stability factors in place. So I do believe the factors all support a probationary sentence. And so for those reasons, I am asking the court to sentence her to probation with the 142 days of credit.
All right, thank you. Ms. Crawls, you have the opportunity to make a statement before the court imposes its sentence. Is there anything you wanted to add?
No, Your Honor, I think Mr. Bichin summarized everything.
Okay.
Thank you.
All right, these matters come before the court today for sentencing. I'm going to note for the record, the matters that are set for sentencing today are case 23 CR 3217, 25 CR 1800. The people have represented that they're intending on dismissing 24 CR 1036 after sentence is entered in this case. Prior to today's court date, the court reviewed the pre-sentence investigation report. I also had the opportunity to review the letters that were provided by defense counsel in support of Ms. Kroll. Here, the court notes first that in the 3217 case, Ms. Kroll was convicted and added count 4 of fraud by check, class 1 misdemeanor, and an added count 5, second-degree aggravated motor vehicle theft, a class 6 felony. In 25 CR 1800, she was convicted of second-degree forgery, a class 2 misdemeanor. The court will note for the minute order that in the 3217 case, Ms. Kroll has, is it 142 days in that case? I just want to confirm that.
That's what the PSI has as well.
Okay.
And that's defense's position.
142 days of pre-sentence confinement credit. And then in 25 CR 1800, Ms. Kroll has 77 days of pre-sentence confinement credit. Ms. Kroll is before the court today, 46 years old. Court will briefly touch on the underlying facts for each of these cases. I know the people have previously represented them, but what the court's understanding of these events is as follows. In the 3217 case, on April 29th, 2023, Ms. Kroll provided a fraudulent financial document, specifically a check as well as employment documents, and purchased a vehicle from Cars with Attitude, the Altitude. The approximate value of the vehicle was $16,893. In 25 CR 1800, on April 4th, 2025, so approximately 2 years later, Ms. Kroll engaged in the same behavior and attempted to pass a fraudulent check at Econo Auto Sales, also in an attempt to purchase a vehicle. Ms. Kroll's criminal history is of significant concern to this court. Her criminal history dates back to 2009. At this time, she has 10 adult felony convictions. And what is of particular concern for this court is that the majority of these convictions are for crimes of moral turpitude, including theft, charitable fraud, attempt to influence a public servant, ID theft. The probation records, specifically regarding 10 CR 2325, indicate that Ms. Kroll had developed an addiction to pain medications. She forged documents indicating she was diagnosed with cancer. This led to a fundraising event for medical expenses that did not exist. The restitution balance in that case is over $40,000, and there's over $40,000 in interest that has accrued. Today, defense has argued that Ms. Kroll should have the opportunity, that the way for her to pay back what she has done is to pay back the restitution that is due and owing. From the court's perspective, Ms. Kroll has had over a decade of time to begin making restitution for what she did specifically in that case. And instead, Ms. Kroll has only engaged in further acts of deception, including in the 2 underlying cases here. In addition to that, Ms. Kroll has been given opportunities at community supervision. Her criminal record shows she failed to respond to probation supervision and instead was charged with new law violations during her periods of supervision. Her LSI score was a 23. The risk factors that were identified by probation included the prior criminal history, the victimization of the community, financial instability, and this lifestyle.
Wait, friend. Wait. But she has felonies. Don't you remember how Australia was built?
Has been existing for 16 years, in which Ms. Kroll is engaging in criminal behavior in a dishonest fashion for her own personal gain. She was not eligible to be screened for community corrections due to her due to her pending felony in the 1036 case, which will be dismissed. However, the court, in looking at her criminal history in its entirety, does not believe she would be a good candidate for community supervision. What the court's going to order here, after considering the factors in CRS 18-1-102.5, I'm going to sentence Ms. Kroll to, in 23 CR 3217, I'm going to sentence Ms. Kroll on count 5 to 18 months in the Department of Corrections, followed by a mandatory period of parole for 1 year. I'm going to order that as to added count 4, she'll be sentenced to the county jail for 364 days. That sentence is to run concurrent to the added count 5. In 25 CR 1800, I'm going to sentence Ms. Kroll to 77 days in the county jail with credit for 77 days time served. And the sentence in that case is going to be closed out. No restitution was being requested. No restitution will be ordered. That's going to be the sentencing order. So Ms. Kroll, at this time, you're going to be remanded into custody.
But Judge, wait a second, Judge. Hold on. You have to hear her out.
With that, we'll be in recess. Thank you. So can I give these back to you? Yes, certainly. Thank you. Which one? Next, we're going to call 25 CR 2762, People versus Kenneth Renault. I'll take entries starting with People.
Mark Campbell on behalf of People, Your Honor.
All right, good afternoon.
Tyler Smith on behalf of Mr. Renault, who appears in person in custody, approaching to my left.
All right, good afternoon. These matters come before the court today for sentencing.
That's a new color combo we got, guys. Puke green pants with an orange shirt. I'm never going to prison. Never, 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 never.
Strike that. This matter comes before the court today for sentencing. Are the people prepared to proceed?
People are ready to proceed, Your Honor.
All right, Mr. Smith?
Yes, Your Honor.
All right, I'll start first with the people.
And Your Honor, Mr. Renault had been accepted into the recovery program as well as the Veterans Treatment Court program. I believe both the defense as well as the people are asking for him to be given that opportunity to go into the Veterans Treatment Court program. He has had some mental health issues, substance abuse issues, Your Honor. He is a veteran. They are ideally suited for him. He has expressed interest in wanting to get his life back on track. And frankly, I think that's what everyone wants to give him. I'd be happy to give the court more information on why I think this is appropriate. If the court is happy with what has been seen on the record, then I'm happy to rest on that.
Give me one moment.
Absolutely, Your Honor.
I wonder if a government can say no. Like, let's say one of our top scientists in the United States wants to move to Australia and become an Australian citizen, not an American citizen. I wonder if America could say, nope, nope, we need you here. You're one of our top scientists. You can't leave.
Okay. Mr. Smith, you can go ahead.
Your Honor, we are asking that the court sentence Mr. Renault to the Veterans Treatment Court. Mr. Renault, will point out first that the facts in this case are, I think it's fair to say, bizarre in their way. That's because Mr. Renault, at the time he was arrested, was experiencing a mental health crisis and was suffering from substance use disorder, and those two things were really feeding each other. And I obtained his medical records from the jail that show that when a mental health assessment was done back in December last year, when he was first brought into the jail, he was behaving, in their words, bizarrely. He was prescribed Zyprexa, an antipsychotic, and has been taking that consistently. It's also borne out in his records. And in the time that I've known Mr. Renault, he's always been a very calm and collected person. It's certainly not the person that those the jail staff had seen during that mental health screening when he was first brought in. Mr. Renault also has a self-professed stimulant addiction, something that he really wants help with, and he really wants to get a grip on because he doesn't want this cycle to keep continuing. I am now the public defender's representative at the Veterans Treatment Court. I've been there a few weeks in a row now, and I can speak firsthand to what a good program it is.
They do have some pretty good programs in Colorado. That's just facts. Jude, I didn't hear about the psychic experiments here, but I have been listening to this podcast called The Telepathy Tapes. It's very good. It's very good.
Mr. Renault, as a veteran, will be around fellow veterans. There's a sort of sense of camaraderie between these folks, these participants, that is unique to that subculture and that group of folks. There are representatives from the VA, treatment providers. Just like in recovery court, there's a lot of oversight, but Veterans Treatment Court is also a much smaller program. There are fewer participants than there are at recovery court. So folks really get a lot of attention along the way. It's certainly nothing like my perception of conventional probation. So there will be plenty of supervision, plenty of oversight for Mr. Renault. And he's looking forward to getting started and getting to work there. Mr. Renault has a pending Garfield case where he entered a plea. They're contemplating a concurrent sentence to whatever happens here. He has a PR bond that's posted in that case. Typically, the court would give a return date of the following Thursday, but he has sentencing in Garfield next Thursday afternoon at 1:30, and he would typically have to come to Veteran Treatment Court at 3 o'clock on Thursday. Because of that court conflict, I'd ask that the court order a return date the following Thursday so that Mr. Renault can appear in that other case that's already set in Garfield.
Can he attend this Thursday?
I'm working to try to arrange or confirm that he can appear virtually in Garfield. The trouble is,
Stephen King ruined handcuffs for me forever because of that book, Gerald's Game. Husband and wife are spicing up their marriage. They go to his remote cabin in the woods, no one around. He handcuffs her to the bed, and then he has a heart attack and dies, and there's a serial killer running around, and there's a rabid dog that eats the husband, and Stephen King ruined handcuffs for me.
Garfield's far enough away where if he were to need to appear at 1:30 there, he'd have to be back here.
Garfield's this Thursday?
Yes, Your
Oh,
Honor.
I was under the impression it was next Thursday. Okay.
The 14th. In the meantime, we'd ask that the court modify bond to personal recognizance so that Mr. Renault can appear out of custody at his first review date in Veteran Treatment Court.
Okay. What's the people's position on that?
Oh, there's no objection to that, Your Honor.
Okay.
Now, Mr. Allen
Mr.
might
Renault,
be able
you
to
have the right
shake me
to
of that,
make a statement. Is there
though.
anything you wanted to add, sir?
You covered it.
Okay. All right, this matter comes before the court today for sentencing. Mr. Renault was convicted and added count 3, attempted second-degree burglary of an occupied structure. Court did review in advance of today's hearing the pre-sentence investigation report. I'm going to note that Mr. Renault has 139 days of pre-sentence confinement credit. Court did review the underlying affidavit, which was the basis for the conviction in this case. Court had some concerns related to Mr. Renault's criminal history dating back to 2007, in particular the menacing convictions, the attempted burglary, second-degree assault conviction were of concern to this court, as well as previous attempts at compliance with community supervision. All of that said, Mr. Renault was in the armed forces. Court believes strongly in the structure of our specialty court programs, in particular, the Veterans Treatment Court. I think it can provide a tremendous amount of structure and support as folks work through these issues. So ultimately, I'm going to sentence Mr. Renault to the Veterans Treatment Court, order completion of that program. Court will convert his bond to a personal recognizance bond, and I'm going to order that he return on, so it'd be the 21st at 1 p.m.
3 p.m.
3 p.m. So Mr. Renault's return date will be May 21st at 3 p.m. Was there any restitution requested?
No, Your Honor, there was not.
All right, no restitution will be ordered. Any questions or further requests of the court?
Not from defense.
Nothing from the people, Your Honor.
Okay. Mr. Renault, this is a tremendous opportunity. I really hope you take advantage of it, okay? I think you have the ability to be successful in this program.
Thanks, sir.
Okay. I wish you good luck as you go forward. All right, we'll be in recess.
Go on, Mr. Renault.
I send them through.
Thank you, Your Honor.
Yes, thank you. Next, we're going to call 26 CR 26079, People versus Kai Rhodes. I'll take entries starting with the people.
Conrad Glover for the people.
Christopher Richardson on behalf of Mr. Rhodes, who appears in custody.
All right, and this matter is set today for first arraignment. Mr. Richardson, how do you want to proceed?
Sorry, here. Your Honor, at this time, we got a little ahead of our skis on this. We were perhaps anticipating a plea today, but that it just isn't going to happen. Part of this is due to the fact that he also has another case that hasn't been a complaint hasn't been filed yet, and so that creates some uncertainty. I think ultimately, Your Honor, we're just asking the court to reset this to June. The June 22nd date, understanding that June 8th is not available.
I don't know if this changes anything. Probation just today, this morning, filed a complaint to revoke probation in the 26 CR 92 case. So if the
Yeah, I'll make sure to get an entry of appearance on that and swoop that up and then start working on it. So I would ask to just set to June 22nd.
Okay. Any objection to that, Mr. Glover?
No, Your Honor, and if that case is going to be opened, it would probably make sense to set both, given that complaint has been filed. But I don't oppose setting to June 22nd.
My only concern is we're gonna, because Mr. Rhodes is in custody, we're gonna run into some time issues with the complaint to revoke.
And Your Honor, I'm prepared to address that now if the court will just give me 1 second.
Okay. Why don't we do that and we can try to coordinate things.
What's that case?
26 CR 92. It helps I can just email it to you.
See if I can pull it up. Yeah, if you can email it, I can't
Cool.
access it. So.
Who else can literally hear the dodgeball slamming into your face? That sound it makes? That's me. I'll be back in the back smoking. Red light, blue light.
All right, Mr. Richardson.
So I just need to pull this up real fast. Great, okay. Your Honor, if the court would appoint the public defender on 26 CR 92, we at this time would waive further reading and advisements on that. We would waive the 14-day rule and ask to set this for a status hearing on June 22nd along with his other case.
Okay. Mr. Rhodes, I'm just going to go through. So complaint to revoke probation was filed in the 26 CR 92 case. You have the right to have a hearing within 14 days of that complaint being filed. The representation today is that you would waive that so we can set both of these cases on that June 22nd date. Do you understand that, sir?
I do.
Okay. Anyone forcing you to make that decision? Okay. Court will then set both cases, 26 CR 92, 26 CR 26079 for June 22nd at 1 p.m. All right. Is there anything else we need to address today?
Not at this time.
Okay. We'll be in recess. Thank you. Next, we're going to call case number 24 CR 2768, People versus Kayla Nanny. I'll take entry.
It didn't show up for me at all,
Conrad Glover for
CJ.
the people.
Didn't even show up for
Tyler
me.
Smith on behalf of Ms. Nanny, who appears in person out of custody.
All right, good afternoon. And this matter is before the court today for sentencing. Are the people prepared to proceed?
Yes, Your Honor.
And Mr. Smith?
Your Honor, we would first
I literally smoked in the girls' room all of the time. Daily.
be asking to continue sentencing. Ms. Nanny has other pending cases in Denver, Broomfield, and Boulder. The outcome of those cases could affect certainly will affect what type of sentence makes sense here. Ms. Nanny's anticipating that those cases.
Donald, have you ever seen her hair? Do not mess up your hair, Monica. Do not listen to him. Just take the hit if you fall.
Cases will result in a probationary sentence. So we'd ask to continue to get some clarity on what the trajectory is in those cases. In Denver, she said on June 8th, in Broomfield, June 25th, and Boulder, May 22nd. I'd ask at least to continue to our June 22nd date, because two of those counties will have been back to court.
Okay.
That'd be our initial request.
All right, Mr. Glover, your position?
Your Honor, I have no idea what's going on in those cases. The Denver ones are fairly new. I think they're just filed in March, or at least bound over in March. Our revo's separate from those, I think, 4 pending cases. I don't know that we can trail them, especially given we don't know how close they are to resolving or not. I think we're just sort of speculating that all 4 of them might resolve before our next docket day. We had technicals here, so people are prepared to proceed. I have no info on what kind of resolution is coming from those cases, and I can't glean anything from the minute orders in data access about there being close to a resolution or not.
Okay. This matter's been pending for a long time in this division. There's a number of pending cases. I would imagine they're all going to take various procedural paths forward. But the court does believe that it's appropriate at this point to go to sentencing on this case without resolution of those. Court notes what Miss Nanny has been convicted of here, which I think sets the parameters of what this court can sentence her to. But again, taking all of that into consideration, we're going to proceed today. Okay, Mr. Glover, you can go ahead.
Man, Judge.
Thank you, Your Honor. I was looking at those cases.
He was
and
not
did access
expecting
me
this.
Filing and couldn't find anything other than a pretrial complaint in the 25 CR 149 Broomfield case. There's not a warrant. It just notes the defendant not calling in at all or taking UAs and I guess having positive UAs when she does take them. Otherwise, I have no updates on what is happening with those cases. Your Honor, our plea was to a DF4 and in a Class 1 misdemeanor carrying a concealed weapon. The probation complaints note testing positive for methamphetamine, missing UAs, missing probation appointments, and then I think we're up to 6 new cases.
Okay, I get getting one new case when you're on probation. I get that. I get tiny bit getting 2 new cases when you're on probation, but not really. I do not understand how someone picks up 6 new cases while they're on probation, especially when they're not phoning in, they're not doing drops, and if they do a drop, it's dirty. How in the world, why is she not in orange? Why?
Picked up while on probation. The PSI was concerning given she states that she's the victim in all of this and doesn't think any of this has been fair. She says she should get probation because she now has someone to take her to meetings and doesn't believe she has or doesn't believe she needs drug treatment, but, quote, if I have to do it, I will.
That was a great Broadway, though,
we're
Micah. 6.
Setting ourselves up for
Excellent.
success when the defendant doesn't think she needs treatment. And we have positive UAs, missed UAs. Some of those new law violations also have drug charges, or at least the Gilpin ones did, but those pled to jail sentences. The defendant doesn't have a great history of success under supervision. I think only one prior sentence was completed successfully. Every other was terminated and revoked. Probation says they don't believe the defendant is amenable to supervision. She really hasn't.
I got this, Monica. I got this. Louis, bite him. Bite him, Louis, bite him.
Done anything while on this case other than pick up those 6 new cases. 2 of them pled, the 2 Gilpin County cases pled to misdemeanors that were closed out with pre-sentence confinement credit. Her prior cases were a felony trespass to auto that was extended, and that's the only successful completion back in 2017. Otherwise, we have a posting private images DV case where a DJ was revoked, probation was revoked multiple times and then terminated. And then a misdemeanor in a Denver Muni case where probation wasn't successful. She has a high LSI. The assessments show she's a high risk to reoffend. And then while on supervision in this case, I believe the PSI reported as absconded and picked up those 6 new cases across the metro area. It's concerning that she blames the other person and doesn't seem to think she did anything wrong in all of this. But I don't think we can help people who don't acknowledge the fact that they have problems or need help. I understand this isn't the most serious case on the court's docket, but the defendant has seemingly been unwilling to do anything while under probation supervision. She doesn't indicate that she believes she needs help. It seems she just wants probation to avoid a custodial sentence. I think if we place her on probation, we're just wasting probation's resources given the other cases will likely control and candidly she's done nothing on probation here. We'd ask for the court just to impose the minimum 6-month Department of Corrections sentence on the DF4, and then close with a concurrent jail sentence on the carrying a concealed weapon.
I do wish, Bren, that you would let Martha show you how she takes pictures of Jack. She holds her phone upside down, takes pictures of him while he's like running with her phone upside down, and then flips the picture, and they look so cute. Lucy, hello.
And we don't object to the pre-sentence confinement credit calculations.
Okay. Mr. Smith.
Your Honor, firstly, before I forget, in the PSI, the calculation in the PSI is different than my calculation for pre-sentence confinement credit. My count was 33 days, slightly different than what's in the PSI. I just want to note that. I'd be happy to go through the dates that I'm basing that off that appear to be omitted in the PSI. Your Honor, we are asking that the court regrant probation here. One thing I want to address right away is the statement in the PSI where Miss Nanny indicated that she's made to do substance use treatment, that she will if she has to, something to that effect. You can tell the court that Miss Nanny didn't understand what the question was asking about it exactly. Her understanding was that the question was pertaining to the halfway house, something different than substance use treatment. Miss Nanny says to me that she recognizes that she has an issue with substance use and wants help with it. She's convicted of a class 4 drug felony here. So I disagree with the contention that she doesn't want help or that she's not amenable to treatment, because that's not the case based on my conversations with Miss Nanny. She thought that the PSI author was asking if she was willing to go to community corrections, basically, and that's not her first choice, certainly, and she wasn't eligible to be screened here, but that's what she thought she was responding to, part of that statement. Miss Nanny has a stable place to live. She also has a lot going for her. She has a job interview this afternoon or this evening at 5 o'clock at a tattoo parlor. The PSI knows that she's been employed in that capacity in the past, and she's trying to get back to work and get herself into a more stable situation. That potential income, is a big piece of that. What Miss Nanny was alluding to in saying that now that she has a ride, she can make meetings and that type of thing, is that she had been struggling with the logistics of probation. The court will note that aside from a couple times when she'd been in custody in other cases or writ failures and that type of thing, Miss Nanny has appeared on bond in this case consistently and appears again today on bond, because now she has help with some of these basic things like transportation to get her to essential meetings, UAs, that type of thing is a big step towards the stability necessary for a person to complete probation successfully. And regarding that pretrial services complaint, Miss Nanny tells me that when she was initially released from the jail, she'd gotten some erroneous information about her obligations on pretrial services in I forget which county it was, but in that other case.
No, she didn't. She didn't. We hear the judges explain everything in detail to them. We hear it every day. So no, she didn't.
Since those complaints, she has called in to the UA line and is doing her best to comply with pretrial supervision in these other cases. This is all to say that I think the contention that these other cases are going to be controlling what happens with Miss Nanny is just as speculative as our position that Miss Nanny is expecting a probationary sentence as an outcome in these other cases. She has struggled with supervision in the past, but has also completed probation successfully in the past. She's a person who struggles with substance use and wants help. Probation is equipped to get her the help that she needs. We asked for a screen for recovery court to give her a bit more structure bit more supervision than conventional probation. And Miss Nanny was unfortunately rejected due to that one criteria that unfortunately comes up every now and again for applicants, where she must have had past multiple supervision and treatment engagements. Not sure exactly what they were looking at when they found that Miss Nanny didn't meet that criteria, but I think it's a shame that they rejected her because of that. She hasn't apparently struggled enough in the past. Because on the one hand, the prosecutor's arguing that she struggled too much in the past to be a good candidate for probation. And then a more fine-tuned probationary program says that she hasn't struggled enough in the past with supervision and treatment. I think that's a shame. Miss Nanny is here before the court asking for help, and we're asking that the court give her that opportunity. Given the nature of the charges here, a probationary sentence with substance use evaluation and treatment are warranted and I think favored by the way the statute is written for drug offenses. So we'd ask that the court re-grant probation.
Mr. Glover, any position on the 33 days versus 21 days?
I was just going back through to do that math, I guess.
Okay.
What were the extra dates?
I had November 3rd, 2024 through November 12, which is 10 days. March 31st, 2025 through April 7, 2025, which is 8 days. August 7, 2025 through August 21st, which is 15, which, if my math is right, is 33.
And I see the difference in math.
Do you want to know why the volume just went louder? Do you want? Should I tell you? Because you guys won't know, but I'm going to tell you. Everything up until this point, what I meant to cut out. I meant to start this clip right here. Professional.
The appearance on bonds were filed days later. Looking at the paperwork, the 11-10 appearance on bond notes bonded out 11-9. The 4-7 notes bonded out 4-6. So I have the 14 days noted at sentencing and then 15 days since the revo. So I think the 29 would be accurate.
Which number?
Oh, 29 days. Did the PSI say 21? I have 29 days going off the appearance on bonds. So I agree that she's entitled to additional credit.
I don't disagree with the 29 days.
Okay. Ms. Nanny, you have the right to make a statement. Is there anything you wanted to add, ma'am?
I really do need the help. I'm willing to do whatever I can to get the help. I mean, I know I didn't do probation that great last time because I didn't have a ride, or like a lot of stuff has happened, but I'm more than 100% certain that I can get through with it and become sorry.
It's okay. Take your time.
I don't know what the word for it is. An actual person, I don't know. Be an actual abiding citizen, or I don't know how you say it, sorry.
Yeah. Okay.
I'm sorry. Thank you.
All right. Thank you, Ms. Nanny. All right. This matter comes before the court today for sentencing. In advance of today's hearing, the court reviewed the pre-sentence investigation report as well as the recovery court screen, indicating that Ms. Nanny was not accepted into that program, which I frankly agree with defense is unfortunate in this circumstance. Here, Ms. Nanny was convicted in count 2 of possession of a controlled substance, drug felony 4, count 4, carrying a concealed weapon, a class 1 misdemeanor. On April 14th, 2025, Ms. Nanny was sentenced to 2 years of probation. On June 30th, 2025, Probation filed a complaint to revoke and request for a warrant based on a new law violation out of Broomfield County, case 25 CR 149. After Miss Nanny tested positive for methamphetamines or amphetamines and failed to submit tests and failed to appear for appointments. On August 21st, the probation department filed an addendum to the complaint alleging she committed a new law violation in Gilpin County. That's case 25 CR 85. On January 14th, a second addendum to the complaint was filed alleging a new law violation out of Boulder County, case number 25 CR 1868. And then on March 10th, 2026, a third addendum was filed wherein it was alleged that Ms. Nanny had committed additional law violations in Denver County. Ms. Nanny has admitted to the technical violations in this case. Those other matters remain pending. Here, the court is going to note for the minute order that Ms. Nanny has 29 days of pre-sentence confinement credit. She's 31 years old. At this time, Ms. Nanny has one prior felony conviction and she has 4 pending felony cases. Generally, one of the things that the court looks at in determining whether someone is a good candidate for probation is previous terms of compliance. Here, Ms. Nanny did not report to probation while pending revocation. Probation was of the opinion that she was not a good candidate for continued community supervision. They were requesting a higher level of structure than probation can provide. I think, as has been referenced by defense counsel, the majority of the issues here relate to Ms. Nanny's substance use. She's used methamphetamine since she was 28, used up through January 2026. Or February 2026. There's daily marijuana use. Her LSI score was a 37, which is high. Miss Nanny did complete one prior term of felony supervised probation. She's been revoked from 3 prior terms of misdemeanor supervised probation, one of which was under a deferred judgment and sentence. Probation also stated that she was a high risk for criminal recidivism and indicated that there was substantial substance use issues underlying these behaviors. Here, the court has considered the sentencing factors in 18-1-102.5. I absolutely agree that Miss Nanny needs treatment. I think that is 100% the issue which has created this cycle of behavior where Miss Nanny is in the community and she's committing new law violations. The amount of time in which she picked all of these cases up is of extraordinary concern to this court. 3 addendum complaints filed based on all new law violations. All of those cases are pending. And then there was no further compliance with probation supervision. This court does not have any indication that Miss Nanny is in a position where she's ready to address these issues. And I have significant community safety concerns based on the number of law violations which occurred over such a short period of time. What I'm going to sentence Ms. Nanny to on count 2 is 6 months in the Department of Corrections, followed by a 1-year period of parole. And in count 4, I'll sentence Ms. Nanny to 6 months in county jail. The jail sentences to run concurrent to the Department of Corrections sentence.
So who wins? Who wins that battle? She has 6 months in jail and 6 months in DOC. Who wins? Where does she go? It's concurrent.
That's going to be the order of the court. Mr. Glover, any further questions for the court?
No, Your Honor.
No restitution was ordered.
No restitution ordered the first time around, and we have no problem with that. 29 days.
Okay.
being noted.
Mr. Smith, anything further?
Your Honor, I'd ask that the court order a co-determinant jail sentence, I believe on the misdemeanor, or note that on the minimus.
Okay.
That'll give some guidance to the Department of Corrections. I'd also ask that the court order a stay of execution of that DOC sentence. As I'd mentioned,
Fine, Judge. You're sending her to jail, but can she not go right now? Can she go like at a different time in her life?
before, Stanley has appeared consistently while on bond. She has some affairs that she is hopeful that she can get in order before going into custody. She's got pending cases where she's on bond in other jurisdictions. She wouldn't be able to evade the sentence, certainly not for long. So I'd ask that the court order something like a 2-week stay.
Okay. What's the people's position?
Your Honor, our chief concern is her not showing up for that sentence. We haven't had any failure to appear lately. I think we've had issues with her getting here because of all her other cases, and all her other cases aren't set within 2 weeks. So we're going to have that same issue given how far they're spaced out. And I think this case has been going on long enough. I don't know what a stay will do other than just delay the inevitable. And I think we're going to have the same issue in 2 weeks where she has all these other cases. So
We're set for sentencing today. I'm going to deny the request for a stay. Ms. Nanny, we're going to have you remanded at this time.
I'm on house arrest. Like,
I know.
still. I'm gonna go. We're gonna wait. Give me a second.
Your Honor. Your Honor, may I speak for a moment?
Sure. We're in recess on this case.
Take her ankle bracelet off so she doesn't have to pay for that when she's.
Oh, understood. I'll have you talk with Mr. Smith about that, okay?
Check my chest.
But she'd have to pay for
I'm going to take a minute.
I'm gonna have a heart attack. Yeah. I'm not running anywhere, I promise, but I have to take this off. I have to take this off because I can't get charged for it either.
Don't take that off.
But he needs to take it. I need to go. I promise. I'll put it in my pocket and I'll... Please. I'm begging you. I can't. I don't feel well. I didn't even get to say myself. I didn't even get to say goodbye. Can I give him a hug first? Wait. I'm trying to give her something.
Okay.
Can you take that?
We'll get it in a minute. Stay back.
Why do I have to do this now? My fucking... I feel like I need to go to the hospital though. My chest is hurt really bad. Please.
They said yes. They just didn't want you getting close when she was right there. Oh.
All right, we're going to...
Yeah.
This guy.
Because
the judge says so.
Mr. Kennedy, did you understand your rights on advisement?
Yes, Your Honor.
Are you a current member or a veteran of our military?
No, Your Honor.
All right, sir, I did find, excuse me, probable cause for your arrest. I don't believe charges have been filed yet. Give me 1 second to confirm that. And that is right. So, sir, we are here to address bond in your matter as well as protection order. Now, I do have one of the listed victims.
We're just happy it's not us, Bren. We're just happy that everything's going on in our life sucks, but at least that didn't happen to us today.
Who wishes to remain anonymous, who has joined us via WebEx. If you wish to make any statements, you could certainly do so with respect to the setting of bond and protection order. Do you wish to make any statements?
No, sir.
And this will be for HV.
This is one bad guy.
Not at this time, thank you.
All right, the court's going to hear first from the prosecution in this matter. Ms. Duhan.
Your Honor, this affidavit is pretty concerning. The allegations are that the defendant engaged in a road rage incident with a family, pointed a firearm at a family that caused, obviously, these citizens to be in fear. Some of the victims in this case are minors, Your Honor. Right now, I would note for the court that certainly this is charged with one count of menacing, but there's an argument to be made that it could be charged for one count for each of the victims that were in that vehicle. And so I don't believe a PR bond is sufficient when the court is considering community safety in this matter. We would be asking the court for a $5,000 cash only bond. We'd be asking the court for standard pretrial supervision, a MIPS evaluation, no firearms or weapons of any kind, no ammunition, that the defendant have no contact with the victims in this matter, that he remain law-abiding, that he report to pretrial services within 24 hours of release.
All right, thank you. Mr. Sheldon?
Yes, thank you, Your Honor. We have no objection to the requested protection order. I think we have no objection to any orders for firearm relinquishment or things of that nature. We would ask that the court grant the personal recognizance bond that is recommended in the bond application, or in the alternative, grant a co-signed personal recognizance bond or a cash bond or a cash or surety bond at a moderate amount. My client explained to me that he does have some money that he can use to post a bond, but he ballparked the upper limit of that up to $2,000. Now, we would ask the court if it was going to impose a cash bond or cash or surety bond, that it allow him to use $1,000. So that way he does have some money that he can use to possibly obtain counsel, pay for his other expenses. My client explained to me that he has lived in Fort Collins his entire life, that he grew up just up the street from the courthouse. His family is all in the area. He's been working pretty much since he was able to work at a very young age. He explained that he has 4 occupations going on right now, including that he runs his own business. And so this is a person with deep ties to the community, deep economic ties, social ties to the community, and historical ties. Notwithstanding the serious nature of the allegations, we do believe that a personal recognizance bond with the appropriate non-monetary conditions is appropriate here, or in the alternative, that a moderate monetary bond, taking into account his financial circumstances, would be appropriate here. Keeping him in custody would remove him from the local economy. It could cause irreparable damage to his businesses, as well as the people who rely on his businesses for their own economic benefit. So, Your Honor, that's our request today. Thank you.
All right, thank you. And with respect to the no contact order, I'll address HV, who has again joined us on our WebEx. There's an indication that you wish to remain anonymous and you wish for your family to remain anonymous. If the court were to issue a full no contact orders, it would be required, obviously, to list the names and or a restricted address. So what would your request be of the court with respect to that, ma'am? Otherwise, the court has to issue on all of these types of matters what's called a mandatory restraining order, which I'll do in this matter, that states that Mr. Kennedy is not to harass, molest, intimidate, retaliate against, or otherwise tamper with any victim or witness to this matter.
Yes.
So, ma'am, what would you like the court to do with respect to the protection order in this matter?
So she doesn't want this man near her ever again in her whole life, right? So she wants a protective order, but she doesn't want him to know who she is because they were completely strangers. It was a road rage incident. He gets out, he pulls out a gun, he walks up to the family, he puts the gun in the car and points it at them. So now she wants to know, what should she do? Get a protection order, which means provide him her name, or don't get the protection order. Husbands. Ugh. Ooh.
I believe you're going to have to put one in place.
Okay. All right. And you understand that that requires that the court list all names.
Yes, sir, I understand.
Okay. All right. So I do have significant concerns for community safety. On the one hand, I have somebody who's got very strong ties to the community, has very limited criminal history. It's a prior DWAI from 2021, and then a class 2 misdemeanor theft from 2011, one other minor traffic matter, and has significant ties here, having lived here his life and having family here and working here. On the other hand, the allegations contained in the affidavit are extremely concerning, that include reports of Mr. Kennedy pointing a gun.
Sir, may I talk?
Nope, hang on one second.
Yes,
Into a car filled with children. It's deeply concerning to the court.
Your Honor, in my defense,
So I'm not here to address whether you're innocent or guilty. I have allegations that are before the court, and I am addressing bond and protection orders. Any of the issues moving forward will be done as this case moves along. My considerations, again, are for purposes of bond, keeping into account the factors that I need to consider by statute, one of which is community safety. The other factor I consider is criminal history, as well as financial resources of the party before me. So taking everything into account, I am not comfortable with a PR bond. However, what I am going to do is set a $10,000 co-PR bond in this matter. Sir, what I'm going to do is order that you remain law abiding. I am going to order that you report to pretrial services within 24 hours of your release. That will be for their standard supervision. The court will authorize MIPS. I do have to issue the mandatory restraining order under Title 18, and that states that you shall not harass, molest, intimidate, retaliate against, or otherwise tamper with any victim or witness to this matter.
So here's what I think that means, Kelly, and I could be wrong, but I think that means he needs to get a co-signer on his PR bond. So if he doesn't come back to court, that person needs to pay $10,000. If I'm right, and this happens to any of you in your life, don't sign that. Do not sign that.
In addition, I am going to require that you refrain from contacting directly or indirectly all of the named victims that we have. There are 8, and those will all be listed on the that protection order, which you'll need to sign. So I am going to order as well that you relinquish any firearms or ammunition within 24 hours and that you not possess, purchase, or control a firearm or other weapon. I'm going to order that you remain at least 50 yards from all of the named victims. So you shall not have any direct or indirect communication with them or come within 50 yards of any of them or where they are likely to be. So, sir, your next court date is going to be May 18th, 2026 at 8:30 a.m. That's going to be in courtroom 5A.
Thank you, sir.
All right, thank you.
Mr. Cardona, good afternoon.
Okay, guys, this one is special. We're going to go through this and we're going to hear what happens. And then at the end, the inmate's going to start doing stuff. And the judge sits there and narrates everything that's going on. No, I'm not. You can't hear me? I bet if I dropped a couple F-bombs right now, every freaking person would hear it. It doesn't look like I'm muted. It looks like I'm fine. I'm going to pretend I'm fine. So the judge narrates everything at the end, and it is epic the way he narrates it. I loved it. Here we go.
Hi, how are you?
Well, thank you. Your case is 26 CR 622. It's set for an advisement today. The court has reviewed this file. I do find there's probable cause. I'm issuing a criminal protection order in this case that tells you you may have no contact with the alleged victim, no direct nor indirect contact. Do you understand that?
Yeah, can I get a standby to assist allowed so I can get my belongings?
Let's talk about that. I had not included that because I wasn't aware that was an issue, but let's talk about that in a minute. For now, as far as the person goes, you may have no contact with that person at all.
Yeah, I understand. And we want to...
I'm going to just pause you for a sec so I can move on, but we can talk about the details in a minute, including the civil standby. Additionally, as a condition of bond, Mr. Cardona, I'm ordering you to relinquish or give up any firearms or ammunition that you may have in your possession or control within 24 hours of bonding out.
I don't have any.
And relatedly, you are required to provide that affidavit, that signed document back to the court confirming that you hadn't possessed any.
I am going to apologize because the victim speaks and I just don't know if she can put a single thought together and spit it out.
To begin with, or that you had relinquished. Okay?
I did that before the hearing.
That is usually the case. You have 7 days to do that anyway. Thank you, sir.
Okay, yeah.
Regarding the bond, Mr. Posey, I'll hear from you, and it didn't include a civil standby, but I'm happy to talk about that too.
And as far as the civil standby, I think the named victim is also here. Yes, okay. And would like to address the court. Do you want me to go first or the named victim?
Why don't we start with the named victim? Okay. Is that Ms. Rucker? Let me get your microphone on, Ms. Rucker. Hold on a sec. Are you Ms. Rucker?
Hello. Yeah.
Yes. So if there's something you want to say about the bond or the protection order in the case, I'm happy to hear about it. Go ahead, ma'am.
So as the alleged victim, the record of this event was not correct to completion. Yes. And I basically left out important information in the initial investigation.
So hold on. When you talk to the police, there's things you didn't tell them? Okay, I'd prefer not to get into the facts of the case right now. If there's anything you want me to know about what you want to happen with the protection order or the bond, you can tell me that.
Well, I'd like the protection order be lifted as I'm not afraid of Julio. And I went and spoke to the bonds people earlier today, and they said that to let them know what happens, and it's that they would support me like in my decision of what to do with, as I already like signed the bond with them to begin with.
Who said that?
The bail bondsman.
Oh, okay. You signed a bail bond in the case?
Mhm.
Not on this case, from previous.
Hold on,
Yeah.
hold on, hold
Just want to
on.
make sure it's accurate.
Julio, just hold on. Hold on.
So in a different case, because the bond hadn't even been set in this case.
Yes, but they are willing to also help with that and keep me on the
Is that like the Jefferson County case?
yeah.
Okay.
And I would still be like on the bonds for the if there's a new one.
Well, if
for
you
the-
post it.
Yeah, they
I got
they
you.
said to just let them know what happens.
Okay, yes. So you posted a bond in a different case, and the bonds people say they will allow you to post his bond in this case if you choose to do that.
Yeah.
Okay, what else?
But because of like our situation, like as like a new family, since I'm pregnant too, he was like, my
Guys, the judge's very, very, very last sentence in like 7 minutes. Epic. Epic.
main like support and like person and caregiver. I think like a PR bond would be preferred since we have like already like other like financial obligations through that. And yeah, I'm just wanting to like be able to reestablish like our like stability and stuff.
Anything
I
else?
think that's all I really had to say today. I was gonna go pick up an affidavit, but didn't have time before, so we're gonna pick one up after. I'm not really sure how that process works, but I do have like we both have support and people in the community that care and want to like see us be successful, which has been great to see. But I understand like, yeah, it's up to you of what happens now today, and we're gonna follow that accordingly. So thank you for letting me address this.
Okay. I got you. Thank you. You just have a seat right there. We're not done, so I'm gonna keep talking. I'm gonna hear from people and keep, and then I'll decide. But you can just stay right there. Bond, if you want to address the protection order, it's kind of put on the table now, and the civil standby.
Yes, Judge, I would second the request for a civil standby. In speaking with Mr. Cardona, he reported to me that he does have a friend who he can stay with in order to fully comply with the protection order. As Ms. Rucker stated, she is expecting their first child. I think she's about halfway through that pregnancy from Mr. Cardona's report to me, and he's really eager to be able to continue to be there for her and support her and their upcoming child. Unfortunately, Mr. Cardona is unemployed right now, and he has incredibly limited ability to post a monetary condition of bond. As Ms. Rucker also stated, they just posted the bond in his Jefferson County probation case, which further limits their ability.
No. They did not post the bond in his other case, ma'am. They did not. She did.
Both his and Ms. Rucker's to post any condition of bond. I would ask the court, I know that Mr. Cardona has a lot pending. I would ask the court to give him an opportunity in this case. It sounds like the named victim has at least some dispute with the facts that were reported to law enforcement that we have in the record before the court today. And as well as, not to diminish the number of cases that he has pending, they are misdemeanor violation of protection orders, at least in Boulder, and a DUI allegation in El Paso County, as well as the Jefferson County probation case. He is asking for a reasonable bond. My request is for a personal recognizance bond with non-monetary conditions.
Thank you, the DA.
I'm asking for a $20,000 cash or surety bond. He has a lengthy criminal history, including assaults and menacings, and several recent failures to appear, along with a pattern of protection order violations. I would point out that he is restrained by 3 different people in various different civil protection orders. He also has history in at least 4 other states. Finally, the allegations in this case are incredibly concerning. The named victim is particularly vulnerable, and he brutally attacked her, tried to prevent her from getting help, and then fled from police. I find it hard to believe that he is eager to be there and support her through her pregnancy when this just happened yesterday. I have high concerns for her safety, for the child's safety, and for community safety.
Thank you. Bond is set at $20,000 cash or surety. Conditions, no contact with the alleged victim.
Mr. Cardona, please stop.
I'll just note, just so the record's clear, Mr. Cardona's smashing his head along the wall and yelling in the room about things being all lies. While he's violently smashing his head against walls. Deputy, just keep an eye, make sure he doesn't hurt himself. It doesn't argue strongly for someone who has emotional regulation or self-control. It's more consistent with somebody with a history of assaults and behavior that is anti-social. Court's keeping the microphone off just so that there's not, defendant doesn't make any further damaging record against himself, including profanities at the court. Conditions of the bond, no contact with the alleged victim or the residents. Pretrial supervision via CJS, Community Justice Services. Defendant has now chosen to leave and not listen any further.
So I see 3.
And he's now directly addressing the court from the back with violent gestures, arguing very strongly that he's not a safe person to be in the community or with this vulnerable victim.
All the credit so that.
Okay. We're almost at the last sentence. Now that was pretty cool. I want him narrating my life. I want him just speaking about what I'm doing, how I'm doing it, where I'm doing it. It would be so funny.
Continuing pretrial supervision via CJS reports.
Here comes his last sentence, guys. It's coming. Snoopy, thank you.
CJS within 24 hours report to his probation officer, where he's on probation for assaulting somebody else. Within 24 hours, no weapons, comply with the firearm relinquishment and the affidavit. A civil standby will be authorized. Filing of charges will be in 2 days, May 13, 1:30. Back here at the jail. Ms. Papazian, you want those misdemeanor cases?
Yes,
Just put them
please,
all
to
together.
trial, the 2.
So let's take 2 cases. Everybody write these down. 25M 2426. 25M 2775. Those cases will be reset to May 13, 1:30 here at the Boulder County Jail, Division 10 case. They'll be trailing this CR case, 26 CR 622. So all 3 cases at the same date and time. Ms. Rucker still here? Ms. Rucker, do you understand what just happened? I just want to make sure you know what just happened.
Yeah, I think.
Okay?
So-
I've set a secure bond. You are welcome to exercise whatever wisdom you want regarding that bond, but the bond is set secured and the protection order remains in place. So he may have no contact with you at all for now. None at all. Do you understand that? Not until the court changes that rule. You're not restrained in any way. You're welcome to do whatever it is you need to do for yourself. There's no rules limiting what you do. You're the protected party in this case. Okay?
And then the May 13th follow-up, is that?
That's in 2 days. That's right back here at 1:30. That's when we'll see what charges, if any, the DA chooses to file in this particular case. And you're welcome to talk to the DA, by the way, and the investigators about whatever it is you want to say. When you said an affidavit, you're welcome to make a record of all of that, okay?
Okay,
Whatever it is you want to say.
thank you.
Sure. Good luck with your pregnancy, and I hope the injuries that I can see heal.
Thank you.
Oh, I hope the injuries that I see all over your face from what you said never really happened yesterday, I hope they heal. Jeez. I bet you next hearing he comes, he's going to be a perfect saint. I bet you. All right, guys. Thank you so much for coming out today. I really, really appreciate it. I do. I'll see you twice tomorrow. Twice. But have a good Tuesday. Behave. And go get some ice cream or cake. Do that. And then tomorrow you can tell us what kind it was. I'm going to go all out. I'm going to go find a piece of ice cream cake today with all kinds of crap on it. And I'm going to go all out. Bye, guys.
Well, I thought I'd write a happy song. I found a chat room where I belong. You don't know how much it means to me. With such a groove, I'm less lonely. Oh, Kathy's the creator, she's leading the way. At Court Vibes, we laugh and we stay. Her smile shines bright, she's got that grace. Come join the fun, it's a welcoming place. I can count on distraction from my pain, 'cause this creator takes you there and back again. Kathy is the heart here, always in stride. Her work is hard, but her joy she can't hide. Oh, Kathy's the creator, she's leading the way. At Court Vibes, we laugh and we stay. Her style is classy, she's always top shelf. Her cases are new with a twist or two. I really like them, I believe you will too. A little lifeline passed along in rhyme. Why don't you join us? It's a guaranteed good time. Oh, Kathy's the creator, she's leading the way. At Court Vibes, we laugh and we stay. Her smile shines bright, she's got that grace. Come join the fun, it's a welcoming place. And so in